Nope, nothing starts here at 9:30 ever. That's okay. All right, sir. I'll recall, obviously, the bond forfeiture. And so, Mr. Van Wright, you were previously in court and entered pleas of...
Court doesn't wait for anyone. When defendants don't show up on time, the consequences start immediately.
True in a motion to revoke your probation and entered plea of guilty in the new offense. Can you send me that paperwork just because this is all... And the agreement was for 2 years TDC, and I gave you a little bit of time to come back and be sentenced today, correct? Were you arrested for anything between that time and now? So if they were agreed, I should have these printed out. We shouldn't have these if they were agreed. There they are. All right, and wait just a second. Sorry, I'm a little out of sorts. What did he plead true to?
There's only one count.
This defendant already admitted everything, probation violations and a brand new offense. And today is sentencing day.
Judge accepted the plea, then delivered the sentence. 2 years in prison, probation revoked, and no right to appeal.
And then changed it. Got it. All right, Mr. Van Wright, in cause number 24 DCCR 2485, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of injury to a child, elderly, or disabled individual. Sentence you in accordance with your agreement to a term of 2 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 15-23582, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find sufficient evidence in that case to revoke your probation.
With no hesitation, the judge accepts the plea deal. 2 years in prison, probation revoked, and no right to appeal.
And at this time, revoke your probation and reassess your punishment in accordance with your agreement to a term of 2 years.
Both cases will run at the same time. It sounds better, but it still means prison.
Institutional Division of the Texas Department of Corrections. You will also receive credit on that for any time that you've been in custody that the law gives you the right to receive. The cases will run concurrently, which means together at the same time. I'm handing you, in each of those cases, trial court certifications that shows that these were agreements that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility.
The judge makes it clear, from this point forward, even touching a firearm could land him back in serious trouble.
To possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can speak with your attorneys. All right, good luck to you, sir. You can go back with the bailiff. Thank you, Ms. Simmons. I know. What? I know.
Just like that, one man is sent away, and the courtroom moves on to the next name.
See, Mr. Lewis on Mark Garcia. Yes, ma'am. Thank you so much.
Judge, I haven't seen him.
Okay, if you call the name Mark Garcia, please.
Last week.
He
Late. He was late last week. It wasn't Marvin had already left, and you told him, "I'm giving you 1 week to get here. I don't care what time you have to leave." Get on a lecture.
Driving in from
Houston.
Corpus or something? I don't know. No. All right, his bond will be forfeited for non-appearance and reset at 100,000. Clifford Norman, Mr. Lewis. Oh, I don't see that paperwork yet.
Okay.
Clifford Norman,
I'm sorry, Judge. I haven't gotten to that.
just have a seat. I'll recall it in just a minute.
He can come up and Mr. Norman.
What about Drayden Rose? Is there paperwork on him? I'll hold it. As soon as it comes through, I'll recall both of those. Mr. Kimler, you've got Ronald Souls.
He's trying to use the habit, Judge.
And this is Miss Malfino on Ronald Souls. Good morning. You're Ronald Souls. And in cause number 25, DCCR 0252, Mr. Souls, you're charged with unlawful possession of a firearm by felon. Case is set for trial to begin with jury selection on Monday, January 5th. What is the announcement?
Brady, Your Honor, I did file a motion to suppress, which I think we can carry with the trial. I don't know if it's going to show up yet. I did that over the weekend.
No, it's not here yet.
We can carry it with the trial.
Miss Malfino.
I haven't seen it yet, but I'm ready.
It's just a warrantless, standard warrantless search.
All right, so I'm going to number the case. Obviously, everybody knows after today, no plea agreements unless something changes drastically with any information that you guys don't already have. Stay in touch with Mr. Kimler. You'll need to be back Monday the 5th at 1 o'clock. He'll know that for sure tomorrow, though, okay?
I think, Judge, if I may, there is a video, and I appreciated the defendant look at it before.
Have you seen the video?
No, ma'am, Your Honor. I wanted to bring this up to the court attention. I'm from Lake Charles, Calcasieu Parish. I don't know if the courthouse, I'm not from down there. And
I don't care where you're from.
yes, ma'am, I
don't mean that mean, but it really doesn't matter. You're still going to be required to be back here for your trial.
Yes,
So, but what I'd like to do is, do you have
And then
that?
I can go upstairs and get it, Judge, and in light of that, Mr. Kimler and I might be able
We
to
can work
have a
it out.
short conversation.
Do you have time to use,
Yes,
we can
absolutely.
get a computer and y'all can sit in the jury room?
Absolutely.
Okay, have a seat until we get all that. We're going to let you and Mr. Kimler watch the video that the state's attorney has. If that changes anything, we'll see this morning. If not, we'll number it for trial. Don't leave, okay?
So,
yes, ma'am.
You've got Richard Robb. It's a sentencing, Mr. Kimler.
he's already pled.
Richard Robb is set for sentencing. You should have a pre-sentence report.
Less than 3 days. Rob,
Oh, okay.
make sure I didn't.
Oh, yeah, it was the lesser include, okay. All right, sir, you're Richard Robb, and this is 24 DCCR 2170. Mr. Robb was previously here, entered a plea of guilty to the lesser offense of a Class A misdemeanor theft of property, and I reset it for sentencing. The agreement's for 3 days in jail, and is there any reason not to go forward with sentencing?
Not that I'm aware.
Not from the defense, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class A misdemeanor theft of property, sentence you in accordance with that agreement to a term of 3 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been incarcerated on this case. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff. You've got Tajuan Mack.
Page one.
I'm sorry, Judge.
Page one, Matt.
Tajuan Mack. Do you need me to take a break, or are you good?
Page one. It should be. ready.
Yes, you
Gotta do like finish the case.
transferring to.
What did the jury think?
No response, Your Honor.
He's been here on every other occasion, so.
His
obviously
bond?
he's gonna be here.
His bond will be forfeited for non-appearance and reset at 100,000 if he gets here this morning during docket. I'll recall that. If we get him or he gets here, what is everyone's announcement? He's set for trial on the 5th.
State's ready for trial.
All right, it would be most likely the number 2 case and need to be, he's a warrant as well? Okay. Well, we'll see. At least we'll know where he is if he gets arrested. Jason Harris, Mr. Kimler.
Yes, Your Honor. Close on motion increase. It's a bond increase.
Good morning, you're Jason Anthony Harris, and this is 24 DCCR 2254. Mr. Harris's case is set for trial to begin with jury selection on the 5th also, and what is the announcement?
We're ready. Also, filed a motion to suppress over the weekend. We
I
can
didn't
carry.
get that.
Well, it's probably been accepting that we can carry it to trial.
Your Honor, the state's also filed a motion to increase the defendant's bond. He was apparently arrested back in August for, among other things, possession of drug paraphernalia. For whatever reason, it wasn't on my radar. I didn't see that. And in our motion, we were asking for an increase in the defendant's bond, or in the alternative, maybe a drug patch, and at a minimum, drug testing for today.
Have a seat in the jury box. Let's get you tested, and then we'll go from there on that. And Brianna Kleinan, it's a sentencing. Ms. Kleinan, before we go forward with you, I'm also going to have you tested. Have a seat in the jury box. Mr. Lewis on Clifford Norman. Good morning, sir. You're Clifford Norman. And Mr. Lewis, will your client waive the formal reading of the indictment?
He does, Judge.
Just a second. Mr. Norman, in cause number 25, DCCR 1034, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from July 15th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you would be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year deferred probation, a $1,000 fine. You would be required to follow all of the rules and conditions of probation, which would include having no contact with a Kenneth Sweat. Do you understand? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I'm required to ask everyone. You understand that? Okay. State tenders number 1.
Okay.
It's admitted. Is there any evidence that Mr. Norman's not competent? All right, sir. I'm going to find that you entered your plea of guilty freely and voluntarily, that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That will give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. Yes, sir. All right, we'll see you back at sentencing.
All right, thanks. Thank you.
And then Drayden Rose, Mr. Lewis.
Yes, ma'am.
Good morning. Are you Drayden Ropes?
Yes, ma'am.
Excuse me. On a lesser, it looks like.
Yes, Judge. That's your class.
So got it. Okay. All right, Mr. Rose, will he waive the formal reading of the indictment?
He does.
Mr. Rose, in cause number 25, DCCR 0789, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault from April 16th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you sign these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for a 1-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? And are you a U.S. citizen? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Rose is not competent?
No objection.
And Mr. Smith, since it's been reduced, is there any history or any reason to get a pre-sentence report? So, Mr. Rose, I'm going to waive the pre-sentence report in your case. I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm following the agreement that you made and deferring all proceedings and placing you on probation for 1 year. You're ordered to pay the $300 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have the conviction on your record. And at the end of the probation period, if you are completed satisfactorily, then the case will be dismissed. You'll never have that conviction. The other side of that is if you violate your probation, you can be brought back into court, found guilty of the offense, and go to the Jefferson County Jail for up to 1 year. Do you understand?
Yes.
I should have something. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. Once you get that, you'll just need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. She's at that desk right over there, so be watching for her to call you up. All right, good luck to you, sir.
This defendant walked in hoping for closure. He walked out heading straight to prison, with sentences running together.
See, Mr. Burbank, you've got John Martin. Ms. Malfino on John Martin. Good morning, sir. You're John Martin. And this is 25 DCCR 0583. Mr. Martin is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
We're still waiting
On what?
on records.
Oh,
Yes, Judge, it looks like there was an agreed order for the CPS records.
back in October. Okay.
And I'll reach out to Ms. Adams.
Okay, that would be great if you would see where they are in that process. We'll just do, let's do about 45 days reset, a little extra time. So hopefully we get those records back before then. You guys can review them and we'll see if we get an announcement. Stay in touch with Mr. Burbank and he'll let you know when you need to be back. All right? Yes, sir. Thank you.